Hello friends, in the series on the income tax cases, today we will discuss an issue regarding the taxability of the waiver of the various type of loans by the banks. The question arises that in case if the bank in a settlement scheme waives off the loan may be working capital loan or term loan. So whether this waiver of loan in the hands of the assessee is a capital receipt or a revenue receipt. This issue has been taken by the Karnataka High Court in the case of IG Petrochemicals Limited versus Income Tax Appellate Tribunal and another, and this case has been reported in 470 ITR at page number 513, and the date of the judgment is 23rd September 2023. In the present case, the assessment year is 2006-07 and the assessee has availed some loans with banks, and these loans included term loan and working capital loan also. The assessee was a defaulter of the bank. The assessee was not able to pay the interest also. So the bank entered into a settlement scheme with the assessee and waived off interest and some part of working capital loan and term loan also. The assessee, when filed his return of income, took the waiver of interest as in his income and treated the waiver of the part of the term loan and working capital loan as a capital receipt. When the assessment proceedings were going on, the learned assessing officer showcased the notice that why the waiver of the working capital loan and term loan should not be treated as revenue receipt. The assessee relied on the judgment of Supreme Court in the case of Commissioner versus Mahindra and Mahindra Limited 2018, which is reported in 404 ITR at page number 1, which says that there is no need to bifurcate the term loan and the working capital loan for the taxability under section 28 clause 4, and since section 28 clause 4 talks about the taxability of the perquisites which are not in the shape of money, and since these perquisites, that is the loan, waiver of term loan and working capital, is in the shape of money, so section 28 clause 4 do not attract and hence it is not taxable. The learned assessing officer didn't accept the submission of the assessee and go ahead with the addition of amount of the waiver of working capital loan and term loan. The assessee filed the appeals before the learned CIT appeal, and CIT appeal also upheld the order of assessing officer. The assessee moved to the tribunal. The tribunal partly gave leave to the assessee. Tribunal said that the loan which is in the shape of working capital loan is not a capital receipt, it is a revenue receipt, while the waiver of term loan is a capital receipt. So the tribunal gave the partial relief to the assessee. The assessee moved an miscellaneous application before the tribunal by again relying on the judgment of Commissioner versus Mahindra and Mahindra Limited 2018. But the tribunal rejected the miscellaneous application, so the assessee filed a writ petition against the order of the tribunal. Generally, the writ petitions are not generally filed against the order of the tribunal, but this is a unique case. And when this matter was heard by Karnataka High Court, the Karnataka High Court said that in the present case, the amount cannot be taxed in the shape of waiver of term loan and working capital loan under section 28 clause 4, because in section 28 clause 4 only those amounts can be taxed which are not in the shape of money, and since the working capital loan and term loan are in the shape of the money, so they do not cover in the definition of section 28 clause 4, and which is also supported by the Supreme Court judgment, and hence the Karnataka High Court remitted the matter back to the tribunal to reconsider the matter as per law. If we conclude this judgment, then conclusion can be drawn that whether it is a term loan or working capital loan, it is waived off by the banks, then it is not taxable under section 28 clause 4. But friends, through Finance Act 2023, which is effective from 1st April 2024, the section 28 clause 4 has been amended, and in that section, that is section 28 clause 4, now all the perquisites have been included, whether they are in the shape of money or not, meaning thereby that this amendment has overruled basically the judgments of the various courts regarding the taxability of the waiver of loans. But before that, we can take the benefit of the various judgments. At the end of this video, once again I am repeating the name of the case. The name of the case is IG Petrochemicals Limited versus Income Tax Appellate Tribunal and another, and this case has been reported in 470 ITR, page number 513. The date of the judgment is 23rd September 2023, and this matter has been decided by Karnataka High Court in a writ petition. Thank you, friends.